which brings us to House Bill 6049, sponsored by Representative Henrys. I'll give you an explanation in 1 second. It's a bill related to criminal offenses, particularly sexual assault. It establishes criteria for the criminal offense of sexual assault when the victim is in custody of a peace officer, provides that a person convicted of custodial sexual assault would face imprisonment for not more than 3 years. Representative Henrys, the floor is yours. Good to see you.
Good to see you as well. It was just a short moment ago that I did. Thank you, Chairman, and thank you, members of the committee. I'm here to, like Rep. Kislak before me, to represent a bill that I found rather odd wasn't already currently in place. I feel that it is rather simple. Under no circumstances should an officer engage in any sexual activity with a detainee, whether they are arrested and in custody, detained in a correctional facility, or on probation or parole. If we are serious about wanting to improve the relationship between law enforcement and the communities that they swear to protect, it is crucial we start by implementing common sense laws that will not only just protect people, but give them security from sexual assault. No one should fear that an officer will sexually abuse them or use their position of power to coerce or force detainees to have sex with them. 1 in 8 women in Rhode Island have been victims of sexual assault, and that is most certainly an undercount. Join me in taking actionable and meaningful steps to protect our community's most vulnerable and hold accountable those who abuse their power in the most horrific of ways. And just as an example for those in the committee, there was a case out in New York. There was a young woman named Anna Chambers who was 18 and was actually raped by 2 officers. She was arrested after being found with weed in the car, and they claimed in court that they in fact had consensual sex with Anna that night and that they were seduced by her. The 2 officers were acquitted of all charges, and this is because in 34 of the 50 states, they're allowed to have sex with detainees, and it is considered consensual, so long as the officers say that it was. And we're one of those 34 states that still allows this, and it's kind of strange to me. It was something that was brought up to me by Senator Sam Bell as an issue, but it was actually something that I had come across on my own prior to the bill being brought up. So I jumped at the chance to be able to revisit it and bring it to your attention. Her tragic experience of sexual assault in the hands of the police happened in New York, but this story is very similar to that of probably countless women in Rhode Island and across the country. So I urge you to not wait any longer in preventing such a despicable and horrific tragedy from occurring here in Rhode Island. It's time that we act.
Thank you very much. Any questions of the sponsor of the bill? Oh, Doc, yes.
Not of the sponsor. It is certainly reprehensible that anyone in a position of authority, such as a peace officer, would engage in this kind of activity. So right off the bat, there is certainly merit in the bill. My question, and it's probably going to be the legal counsel, is if this law were to go into effect, is this in addition to other laws that we already have on the books regarding sexual assault? In other words, is this are we creating a different category, or are we adding to our additional sexual assault statute?
This would actually be an amendment to, I believe it's Chapter 11-37. So it would be an
Okay, so
in addition to the statutes that deal with sexual assault, first, second, and third degree.
are the penalties greater than what's already in the statute?
I'm sorry, could you repeat that?
No, with all due respect, I was asking legal counsel. Thank you. I want to know: would this be in greater than the penalties already on the books for sexual assault?
Is it greater? No, No, the penalties for sexual assault. The penalties for first, second, and third degree sexual assault are all more than this particular statute. Are more than this. The third degree sexual assault, it's 3 to 15 years. Second degree is up to 15 years, is all different.
And we're only giving someone 3 years for this?
Well, the sexual assault statutes talk about sexual penetration and other offenses resulting from force, coercion against someone's will. This doesn't necessarily apply to, in other words, this is making a classification for someone in custody, and it doesn't have all of the requirements for a sexual assault under the first, second, and third degree statute. They all, this statute or bill appears to indicate that it's a sexual assault as a result of being in custody and is not so much non-consensual, although it could be. That's my reading of the statute.
Okay, but the penalty is less?
Yeah, the penalty in this statute would be up to 3 years.
Yeah?
But this statute covers consensual, in my opinion, consensual acts for someone who's in custody, and I know that you're trying to trying to stop that type of activity, whether it's consensual or not.
And I agree with that.
Right.
What I'm trying to wrap my head around is, and maybe I'm misunderstanding you, would the penalty here be less, equal, or greater to an equal assault in the other statute?
This is, right, this is less.
And
Because
I
this
guess,
could,
so I'll just leave it with this. It begs the question, why? Why would it be less?
because this, in my reading of this bill is that this bill proposes that by virtue of being in custody, whether the activity is consensual or not consensual, if it's consensual, it's still a crime. If it's unconsensual, it could be considered a first-degree sexual assault or a second-degree sexual assault.
Okay, thank you.
It's by nature of that being in custody.
Now I got it. Thank you.
I may not have explained it as well as I should have.
No, you did. I probably didn't wrap my head around it. Thank you.
Thank you. Any further questions? Oh, Jason.
Thank you, Chair. Rep, why, I'm sort of going to piggyback on Representative Chair Corvasi's question. Why would an officer convicted of this be excluded from the registration statute?
So that was actually something that was discussed with myself and the senator who's also doing the twin bill. We had reservations about placing them in the registry and what that would actually do. We're not in full agreement that the registry itself would prevent this from going forth. As far as we don't think it's the best practice, even though I truly believe that people who have done sexual assault or been convicted of sexual assault should be known, and that it shouldn't be something that we encourage by any means, but we weren't sure that by having them in the registry it would actually benefit the issue. But I was glad that you actually commented. I know your background in this issue, that you are very well versed in this, so I'm open to feedback.
So I appreciate that. I know we have another bill, I think it's on tonight, that's of a similar vein. Do we have the teacher bill on tonight as well?
I don't think so, not tonight.
We have two bills floating around where sexual assault is defined by the professional relationship between the accused and the complaining witness or the victim. And I just want to say that I'm terribly uncomfortable with expanding the realm of sexual assault into these areas where because, frankly, we have a comprehensive sexual assault law on the books, which involve force, coercion, surprise, age, and the penalties that go along with sexual assault are swift and, well, they're not swift, but they are severe. They are life-altering for everybody involved, and they go, in some instances, for the natural life of the accused. And that's not just jail. It's just, even if you catch no jail, you'll have to answer to the government for the rest of your life. I mean, there's a lot of stuff in there if you get convicted of sexual assault. And this bill here, while I acknowledge that it would be despicable behavior, I'm not so sure that it veers into the criminal space by redefining sexual assault. I'm not so sure that's a good idea, particularly when I think there are other legal tools in place to punish this sort of behavior. Everything from professional standards to the civil law. And particularly if the bill comes and we're going to carve out some things. If we're going to call this sexual assault, why isn't it an up-to-life offense the way the other one is? If we're going to call it sexual assault, why isn't it a registration offense? If we're going to call it a sexual assault, why is there leeway on the jail time at all, right? Why isn't some of it, non-parolable or non-deferrable? So I think those are the questions that we have to have in here. We have to think about how this mixes in with our current standard, and I say that as respectfully as I can, because there are some people for sure who commit these crimes and need to be punished, and it's right and good that they are subjected to the penalties that are in the law today. But I really worry about expanding that circle because those penalties are so severe.
And thank you so much, Vice Chair. I really truly feel that where this kind of comes into play a little bit differently than some of our standards as it is right now is the sense of authority that is in play. When we're looking at this right now, people who are detained and in the custody of those who are considered peace officers may not be in right mind to be able to actually, really to make that decision and feel like they can be in a court and actually represent themselves. I mean, we heard our bill earlier regarding like those who are participating or who are identified as sex workers, and how it's so easily founded that criminals or those who were arrested may not be as favorable in the courts, no matter how good of an attorney or representation they may have. And I just think in this case, if we're looking to really, again, foster those relationships with law enforcement and have that trust there, I understand the standard is there, but I think we do have some type of obligation to kind of look at this more closely and say, hey, there's an opportunity for people to be protected by the law from those who could be abusing their power in law.
And I respect that. I would, as I think about the issue, another avenue to achieve that goal, but still keep sexual assault in the circle that I talked about, might be to redefine coercion in the current sexual assault standard to create, I don't want to say a presumption because that gets problematic, but effectively a presumption that if the person is a police officer and a person of authority and the other person's detained, then coercion is present, and thus the sexual assault law that's on the books now, first and second degree, then comes into play. We could redefine coercion, right, but keep the same penalty structure and treat all people convicted of sexual assault the same, in that they enter the ring together and they're subject to the same standards. Just an idea.
I appreciate that. Thank you.
Can I say something?
Justine first. Justine.
Thank you. I was thinking of something similar to what Representative Knight brought up. Really, when I see this bill, it's a bill about consent. When we talk about sexual assault, like when somebody, for instance, is too intoxicated, we know they can't consent, right? And so when somebody is in custody of a police officer, I also do not think they're in a place where they can consent to having any sort of sexual relations, which I think is similar to what Jason was talking about. Just by the nature of being in that situation, they're already actually committing potentially sexual assault that we already have laws about, because really this is just redefining the fact that you cannot consent in that situation. because of the dynamic, which would mean consensual sex is not possible, and any sort of sexual act would be assault.
It's a form of statutory rape where consent is not an issue, yeah. Yes, Chairwoman.
Thank you. I totally get what you're trying to get at, Representative Henrys. And, women are particularly vulnerable to male officers in any category where they could ask for sexual favors and allege that they will let you off for the crime, they'll let you go free. I mean, so women in particular are vulnerable to this. So I think you're on the right track. I just don't know if we can put it in the sexual assault statute. I think we have to clarify a little bit, but, it is an issue for women, there's no doubt. And I think you're on the right track with this bill, so it's something we should really look closely at. But thank you for bringing it forward, because you've heard it for years, we've all heard it. It's been going on for centuries, where a police officer pulls a woman over and, you do X, Y, or Z, and I'll let you go, right? Or I'll give you a ride home, or however. And that may not turn out to be the case. So, in any event, it's been an issue, and thank you.
Thank you. Yeah, and just to further that point and kind of drive your point home is that even in the case that I had presented out of New York, when the presiding judge addressed Anna, she actually got charged with some sort of bribery, as if she was trying to bribe the officers to let her out of the action. So I agree with Rep. Caldwell and Vice Chair Knight about this could be a matter of let's talk about what consent actually is. Let's redefine what coercion is, because it is an actual problem. And I think when we're looking at authority here, especially in these roles, we need to make sure that we have that in check, and we're not lenient here. I just feel like with this particular bill, it's trying to safeguard those who maybe don't feel like it would be favorable in a court when the officer of the law is involved.
Okay, any further questions of the sponsor? Seeing none, first witness is Melissa Brodeau. Melissa, can you hear me?
Yes, I can. I'm here.
All right, you're on the air before the House Judiciary Committee.
Yes, thank you so much for allowing me to testify again. But I'll briefly reintroduce myself. My name is Melissa Bruto. I'm an attorney and advocate for sex workers and survivors of trafficking. Thank you so much. I've been listening to, I'm voicing my strong support for House Bill 6049. I've been listening to the really interesting back and forth, and so I have some words that I prepare, but I also do want to address some of the points that have come up in this conversation. So, as somebody that has represented sex workers and survivors of trafficking for many, many years, it's not an understatement to say that, it's not an overstatement, sorry, to say that nearly all of my clients have been sexually assaulted by police during their lives, specifically trans women and trans women of color, because police know that they can get away with it, right? If you give me a blowjob, I'll let you off. That is a story that I hear, on an extremely regular basis. So I think, certainly there is a need for this particular carve out. I think, yes, there are sexual assault of course, statutes on the books in Rhode Island, of course, but there has to be this particular carve out, whether separately or within the existing sexual assault laws, because cops are never held accountable. And it is something that is really routine. It is almost, something that is done on a daily basis, especially to those who are the most marginalized, to sex workers, to trans women, and police are just never held accountable for this. So I think that there does need to be a particular carve out. Certainly, I understand that there is currently a robust conversation about, again, whether they're in a separate statute or almost the presumption that Representative Knight had discussed. And similarly, as a fellow, someone with defense background as well, I am also always cautious about expanding, criminalization, expanding liability. That being said, this is an area that there needs to be a particular message with teeth in it sent so that people who are the most vulnerable are not continually taken advantage of. Thank you so much.
Thank you very much. The next witness is Henry Binnix. Henry? Henry?
Yes.
You're on the air. You can testify.
Okay.
Thank you.
Thank you. My name is Henry Binks. First off, I'd like to wish you all a very happy Women's History Month. And I would like to make one thing very clear before I share the information that I have. Even though this bill pertains particularly and mention anyway folks in the sex industry, I do believe in my heart that this is an issue that reaches beyond the sex industry. I think it is a public safety issue, an issue that spans across gender, race, class, and ability. So in 2018, the ACLU released an article on police and their sexual encounters with detainees, and it was entitled, "There's no such thing as consensual sex when a person is in police custody." So at the top of this article, there's a story of a woman who was arrested, cuffed in a van, and raped by her 2 detaining officers. Forensics found DNA matches for both of these officers that were accused, yet the officers in question might have been protected by a law that was present in New York at that time, citing that consensual sex between police and detainees was perfectly legal. And I hope the issue here is obvious, because consent is an educated decision articulated by a person with full agency and freedom of movement. So the question that I would bring is, how is it possible to give consent to physical intimacy when saying no or resisting could mean the relinquishment of one person's freedom? I don't think it is possible. I really believe that until this nation holds accountable the very officers whose sworn duty it is to protect from and prevent sexual assault, we will never know safety from rape culture. Victims will never know healing space. And our society as a whole will never move past this epidemic of sexual violence that plagues us today. I'm going to share something personal, and I won't be graphic. I'll try to be brief. So surviving my own experiences with the knowledge that in my own state, historically, police have been given the exception of regulations regarding sexual assault leaves me really discouraged beyond words to ever come to the justice system for protection. Because the very officers that may handle my cases may be perpetuators of violence themselves. I often fixate on the very real possibility that not only my assailants, but the assailants of so many other people that I know and don't know will never meet the consequences for the things that they took from all of us. Thank you for your time and consideration.
Thank you very much. Any questions of the witness? Okay. The next witness is Gregory Wakazmuski. Greg.
Hello, good evening.
Good evening.
Can you hear me all right?
I can. You're on the air.
Thank you so much, Chair Representative Craven. I just want to start out by thanking all of you for your immense amounts of service to the House Judiciary Committee and thereby everybody in the state who's seeking greater justice under our laws. This has been a huge evening. We've had a lot of testimony on a lot of bills, and this isn't the last one, so I'll try and keep it brief. I appreciate the breadth and wealth of legal knowledge from an incredible group of people. Your nuanced and informed insights are really going to help, again, create really wonderful policy. We're looking at a couple of really interesting, exciting bills here. 6049 in front of you tonight, and 0249 in the Senate coming up real soon. These are an opportunity to deal with, in the Me Too era, power, abuse of power. You know, this kind of statute is going to cover from abuse all kinds of people while they're in custody. This is an attempt to regulate custodial assault. People who are in custody. Now, it's been said tonight that whether it's a law enforcement officer or a gatekeeper for a social service, a teacher or a landlord, these are positions that necessarily involve an imbalance of power between those who have and those who do not. And it seems on first blush, and even after a depth of consideration, that nobody thinks that it should be an area that power should be able to be abused. But I think that there's something quite interesting about trying to put into law this definition of a custodial abuse of people by other people. You know, there are a lot of folks out there who, you know, when they talk about the police, when they talk about law enforcement agencies, when they talk about this job, you know, it seems like these are people who are out there, you know, they're trying to catch crime. You know, they're trying to go out and they're trying to catch bad things. They're trying to catch people. You know, they're people catchers or crime catchers. And it just doesn't seem like there should be any opportunity to test the character of the individuals who are in that job. Now, whether that job needs to be around or not isn't for us to decide tonight, but why offer them an opportunity for fairness to be tested by the person in the car at a traffic stop or, you know, somebody else in some other situation? I think it's very, very interesting that this isn't an attempt to expand or redefine anything in the existing 1137 chapter, but we really do need a law that expressly defines that any sexual activity between somebody in a position of power and somebody who they've caught or detained is not consensual. There is absolutely nothing right about that, and that's what this kind of law would send. It's a signal. It's a signal to everybody in our state that that kind of relationship is wrong. Just as it would be in a school, or just as it would be in a social service, or, you know what I mean?
Yeah.
Now, I understand that there are a lot of lodge members that are afraid that, you know, their profession would be considerably maligned just by a statute like this being mentioned in the public, let alone being passed. And, you know, even that this kind of statute is found to be necessary, you know, by really great elected officials it's pretty damning. But I have to ask all of you, what are you afraid of? Sending a signal that, as Caldwell mentioned earlier, that we need fairness? I think that we're all going to be pretty brave when we really, at the end of the day, consider what kind of signals that we're sending out of this committee. Again, my hat goes off to all of you. It's been an incredibly intense session so far, and it's not looking like it's going to get let up anytime soon. But we all know out here in my neighborhoods, you know, in all the circles that I run in, that you all are doing the greatest job that you can, and we urge you to really recommend this up. Get it onto the floor, get it into law, send the signal that our state needs.
Well, thank you very much, Greg. Thank you very much for your testimony. Any questions from the members of the committee? Seeing none, our next witness is Haley Norris. She's not available? Okay, our next witness is Randall Rose. Randall, are you there?
Yes,
Please keep it brief. You have the floor.
thank you. like everybody else, I'm in support of this bill. It only applies in cases where you can't prove first or second degree sexual assault under current law, but it does create a way to deal with these egregious kinds of assaults. I do support the suggestion by several people that we might just want to add this to regular sexual assault law and not have a lighter penalty for sexual assault by police who are violating the public trust by having sex with people in custody. I don't believe most police officers do that as it stands, but I think we have to stop the minority of police officers who are willing to so outrageously abuse their authority. I suppose it's not completely impossible that somebody could actually want to have sex while handcuffed by a police officer, but I think it's extremely unlikely. And if you have sex in that, if you have a case where people have sex in that situation, 99% of the time or more, it's going to be a case where the person in custody was not willing in any sense to have sex and was just being pressured into it. And so for the same reason that we consider it rape when somebody is very drunk, and when somebody is very drunk, even if there's a slight chance that they were really doing something they would be willing to do under normal circumstances, most likely when somebody's very drunk, they're going to do things they regret. So we have a law saying don't have sex with someone who's very drunk. This is the same kind of case, even though there may be a very small chance that somebody might be willing to have sex without any coercion. It's really unlikely, and sex under those circumstances is very likely to be the result of pressure. So it's much better policy to say it's not legal to have sex in that circumstance. And if there is anybody who actually enjoys having sex with a police officer when handcuffed, do it when you're not in custody. Okay. Sorry, I had to say that. But
thank you, Randall.
Yeah, anyway,
thank you for your testimony.
Thank you.
Thank you very much. And thank you, Representative Henrys, for bringing this forward. And that concludes testimony on House Bill 6049. Next is House Bill 5563 by Representative Casimiro. It's an act relating to food and drugs, the social host regulations. It authorizes the imposition of civil and criminal penalties against any person who purchase, furnish, procure marijuana, or permit marijuana to be used by others. Representative Casimiro, you have the floor.
Thank you, Chairwoman. This bill came to me from former Senator Tassoni, who does a lot of work in substance abuse, and the intent is to just put marijuana into the social host laws where alcohol already exists. It's pretty straightforward. We do need to have one sub-A on it. We have to have the age of 21.
Very good. We have one witness. Any questions by members of the committee of the sponsor? Seeing none, we'll go to our first witness, Randall Rose. Randall, are you there? Randall, are you with us?
Yes, I am. Thank you.
Okay, you have the floor.
Thank you. So I am opposed to this bill, and as actually it doesn't just apply to marijuana, but to any kind of controlled substance. Basically, the bill means that normally people will be punished for being the host of a party where drugs are consumed, even if the host didn't know that drugs are consumed. So the provisions of this bill say that the host of any kind of gathering, not just parties, but any kind of gathering, the host has to take all possible efforts to make sure that drugs aren't used, and if drugs are used without their knowledge, and it can be claimed that they did not take all possible efforts to ensure that drugs aren't used, then they're going to be subject to a really large fine. I don't think that's realistic. There are all kinds of gatherings that take place in Rhode Island every day, not just teenage parties, but adult parties and all kinds of social gatherings of all sorts. It's not reasonable to expect that the host of every sort of gathering is going to take all kinds of efforts to keep somebody who's addicted to drugs from using drugs at the party. Addiction is a serious problem. If somebody's addicted to drugs, they're going to use drugs at whatever gathering they may be at because they have an addiction problem that they don't know how to deal with, and they will find crafty ways to do it, perhaps. It doesn't make sense to punish the host of whatever type of gathering it is over that. And then this bill goes even further and says if the host is under 18, then the parents of the host will bear the fine, even if the parents weren't even there. I'm sorry, but I think this is getting further and further away from from looking at who's really able to have any control over this. If the parents aren't there at the gathering, they shouldn't be punished. And unfortunately, I mean, we could wish that the host of every gathering could prevent people from using drugs at gatherings, but hosts have their minds on other things. It takes some talent and effort to make a gathering go well. They can't reasonably concentrate all their effort at preventing people from using drugs, especially when these people are addicted. So I believe this is a really unreasonable bill, and what's going to happen is if anybody is found using drugs who's been at a gathering or who is at a gathering, police are just going to automatically hand out this $500 ticket, and hosts who have done nothing wrong and didn't even intend to allow drugs to be used are going to decide, well, I might as well pay this hefty fine because it's going to be too much trouble to get tested. I don't think that's a reasonable outcome, and I don't think it's going to really help make society better. So I'm opposed to this bill. Thank you.
Thank you very much for your testimony, and thank you, Representative Casimiro. That concludes any questions of the witness. That concludes testimony on House Bill 5563. Next, we go to Representative Felix's bill. This is House Bill 5982, entitled An Act Relating to Criminal Procedure, Identification and Apprehension of Criminals, repeals requirement of $100 fee for expungements, and requires that the court administrator advise general treasurer and/or the registry of the court that any bail money or on deposit be returned to the defendant or surety. Representative Felix.
Thank you. So this bill is simple as already explained. It repeals the $100 expungement fee that is due when a motion for expungement is granted. Additionally, it mandates the court that within 5 days of motion to expungement is granted to notify the treasurer's office that the motion was granted, and so that the monies can be returned to the defendant. Of course, if there is money to be returned, because we know that any fees or fines that are imposed are taken from the money. The idea is that if there are funds that need to be returned to the defendant, that we don't impose additional burdens by having them reach out directly to the Treasury or to others in order to get that money returned. And as the AG stated in his testimony, a lot of folks don't have the $100 to be able to pay for a motion to expunge their records. We should be making it as easy as possible for folks to be able to get their life back on track. As someone who had a felony on my record for over 2 years, it was difficult to do anything. It was difficult to hold a job. It was impossible actually, to go to school or housing or anything. So I think we should make it easier for folks. Luckily for me, it was automatically expunged, but for others, that $100 could be a barrier for them to get their record expunged. So again, the goal of this bill is to make it easier for folks to get the record expunged when the time comes. and to make it easier, again, to get any monies returned that are owed to the defendant. Thank you.
Thank you, Representative Felix. Are there any questions of the sponsor? It is a good bill. We like your bill. So, seeing no questions of the sponsor, we have one witness, Hannah Stern from the ACLU. Hannah, are you with us?
I am.
The floor is yours, Hannah.
Thank you. Thank you, Madam Chair and members of the committee, again for your time this evening. My name is Hannah Stern. I'm testifying on behalf of the ACLU of Rhode Island in very strong support of this legislation, and we'd like to thank Representative Felix and the sponsors for introducing this bill. We testified in support of a similar bill introduced by Representative Knight a few weeks ago and similarly strongly support this legislation for many of those same reasons. It has been the position of our organization that if an individual qualifies for expungement of their record, there really should not be a price put on that expungement. All that does is place a financial hurdle, which truly could be prohibitive for some individuals. This bill ensures that all qualifying individuals are able to appropriately and equitably seek expungement. So, again, we're very much in support of this important legislation, and we urge its passage. Thank you for your time. I'd be happy to take any questions.
Any questions from the members of the committee for this witness? I think it is a good bill. I mean, you hate to see someone not get their record expunged because they don't have the $100. That's an injustice right there. So thank you, Hannah, for your testimony, and thank you, Representative Felix. The next bill is House Bill 5881 by Representative Malzakowski. It's an act relating to criminal offenses, sexual assaults. It provides that a school teacher or employee that engages in sexual penetration of a student over the age of 14 and less than the age of 18 shall be guilty of third-degree sexual assault. Is Representative Malzakowski with us? He's not with us. So, let's see. So we have one witness. Again, that's Hannah Stern. Hello, Hannah. Are you with us?
I am. Hi again.
You might as well just stay on the line. Okay, you have the floor.
I'll hear more. All right, thank you again, Madam Chair and members of the committee for your time this evening. Again, my name is Hannah Stern. I'm testifying on behalf of the ACLU of Rhode Island. And we just want to express some concern about the breadth of this legislation. We're very sensitive to the situations that this bill seeks to address. But what we're concerned about is that the ambiguity and broad language within this bill could accidentally criminalize some entirely consensual young adult relationships and put particularly young individuals at risk of incurring a felony charge for circumstances that are ultimately totally unwarranted. So this bill would apply to any person, quote, acting in the place of a parent or taking on, quote, parental responsibilities, which could apply to a very broad and disparate number of very innocent circumstances. You know, under this bill, for example, even with the exemptions in this legislation, a 20-year-old who drives their 17-year-old partner home from school every day, which could be considered a parental responsibility, could be charged under this language regardless of the consensual nature of their relationship. Or again, even with the exemptions in this bill, if that same couple volunteers together and the 20-year-old just has senior status, it could be the same issue. So it may differ in personal opinion whether these relationships are appropriate, but they certainly should not carry the burden of a felony conviction, especially for consensual and likely very common young adult relationships. And we're sure this is not the intention, but as written, we're just very concerned that this bill could have the unintended consequence of creating just that potential. So thank you very much again for your time and your consideration. I'd be happy to take any questions.
Thank you, Hannah, for your testimony. Representative Knight, did you want to make a comment or a question?
Hannah, hi. I don't so much have a question for Hannah, but I just want to point out to the committee that I think that the issues that I brought up in the police officer bill are present here. And as we talk about it more sort of at a sidebar, it seems like that we might be able to get two birds with one stone by rethinking the coercion element of the current sexual assault law.
Mm-hmm. Thank you, Representative Knight. Any other questions from the members of the committee? Seeing none, that concludes the testimony on House Bill 5881. And that brings us to Representative Knight's bill, House Bill 5649, an act relating to criminal procedure, bail hearings, entitles criminal defendants charged with enumerated serious criminal offenses to a bail hearing within 14 calendar days of their initial court appearance. Representative Knight.
Thank you, Madam Chair. This is a pretty simple bill. Today, right now, if a person charged with a serious crime is brought before a judge of the district or superior court, and the government, through a police officer, says, look, it's so bad, I want you to hold him without bail because we think he's dangerous. The judge is going to, today, is going to hold that person without bail, and 14 days down the road, they're going to get a hearing, an evidentiary hearing, as to whether or not they actually are dangerous and whether or not they should get bail. That's the procedure today. That procedure is outlined in case law. That's law from the court. There's no statute that provides for this procedure. With this bill, I would codify that procedure with one very significant difference. Today, when the government asks for the hold without bail, the judge can only hold that person without bail. They have no choice. The judge's hands are tied by the prosecution, by the police, when they present the person to the judge at that first appearance. And for those at home who don't deal with this stuff, you may be surprised to know that it is always a police officer who makes that presentment. It is not the Attorney General. It is not a lawyer for the state. It is not someone licensed in law. It is not someone trained to make criminal law punishment recommendations to judges. It is a police officer who, that person alone, makes the decision whether or not to request the hold without bail. And it may surprise the folks at home even more to know that roughly 40% of these cases, when they get down the line in 2 weeks, those persons are going to get they're going to get bail because they're deemed not to be a danger to society. So in those cases, you have roughly half the cases are persons who sit in jail, maybe lose a job, maybe lose an apartment for 2 weeks before they get their turn in front of a judge, and a judge says, I don't think that guy's a danger, or the case is super weak and it's not going to go anywhere. I'm seeking to shortcut that process a little bit by giving the judge the discretion at all times to set bail, regardless of the government's request. Because sometimes, and I've seen it with my own eyes on multiple occasions, the police will bring a charge underneath, they'll bring a charge that the law allows for someone to be held without bail. They'll bring it on weak or somewhat non-existent evidence, or even mistaken evidence, like the cops just got it wrong. And they'll ask for the hold without bail, and the judge absolutely doesn't want to hold the person without bail, but they have to because that's how the law is structured today. If they had their discretion, they would say, I don't believe this person is a danger based on this, that, and the other thing elements. I want to give the judges the discretion that they should have so that they can control the process, and they alone are the ones who are in charge of bail for every person who comes before them on every crime from the lowest level to the highest level. I'm happy to take any questions.
Thank you, Representative Knight. Any questions of the sponsor? Seeing none. That was such a great presentation with speechless.
I just want to add, really, for the committee, this is a small thing, but it is a major source of injustice in our system, because the cases that these people are presented on are the serious ones, right? Everyone defaults to holding them without bail. The judge ultimately has to make the decision. I just want to give the judge the ability to make the decision early in the process rather than later in the process. That's it.
Very reasonable. I think we have a question from Representative Baptista.
Not a question, just a statement. In the words of Representative Knight himself, good bill.
Good bill. Yes, it is. I like this bill. Gives the judge discretion. Thank you, Representative Knight. There are no witnesses, so that concludes.
Madam Chair, I have a question.
Oh, Edie.
It's Representative Agello.
Representative Agello, I didn't see a hand up. So, yes, proceed.
Question for the sponsor. How long has this situation been going on that judges' hands were tied and they had to keep the person incarcerated if that's what the police said?
It's been going on at least since the 1988 rewrite of the Rhode Island Constitution, which created Article 1, Section 9, which is the hold without bail provision in the Constitution. There's a case on point, of course the name escapes me, where the court sort of lays out the procedure on how to deal with that hearing. Frankly, the question of whether or not the judge can set bail or not set bail at any time is still somewhat of an open one, because I'm not aware of a case that nails it down entirely. But I will tell you this, that as by custom and by practice, if the police officers show up and say, hold that guy without bail, I bet you 95% of the judges in the district court think that they have to do it, and the other 5%, while they may have a question, are going to do it anyway because that's just how it's done. If we write it in statute that there's a different procedure, or we clarify the procedure we want to use, it's going to change the dynamic on the ground right away.
Thank you.
Thank you, Representative Corvesi. Please, Chairman. Okay. Don't say I didn't give you a chance. And that concludes testimony on House Bill 5649. The next two bills are going to be taken together because they have the same witness. Both bills were put in by the Attorney General at the request of the Attorney General. House Bill 5871 by Representative Amore is an act relating to motor and other vehicles, motor vehicle offenses, extends the look-back period for a third and subsequent driving under the influence offense, and a refusal to submit to a chemical test to 10 years from the current 5 years. So that's the first bill. Before you get them on the line, I'm going to bring the other one into play, which is House Bill 5724, which is sponsored by myself. This is related to criminal procedure, interception of wire and oral communications. This act would add felony violations of the Uniform Act of Prevention of and Remedies for Human Trafficking as a designated offense for an application for an order under the interception of wire and oral communication statute. So both of these, we have Ryan Holt, I believe, is our witness on both these bills. Good evening, Ryan. Are you with us?
I'm here, Madam Chair. How are you?
I'm very good. So I put both bills into play. Whichever one you'd like to testify on first, you let me know. Either, which one do you want to start with?
I will start with the look back, 5871.
Okay. You have the floor.
Well, thank you so much, Madam Chair, and ladies and gentlemen, good evening. This is Ryan Holt, the Director of Legislative Affairs for Attorney General Noronha, testifying in support of House Bill 5871, which Chairman Amore introduced on our behalf. I came before this committee a few weeks ago in support of, I think, a bill that mirrored this. But basically what this would do is it would amend our look-back statute for DUIs for third and subsequent offenses, so very serious and dangerous offenders, for us to seek sentencing enhancements for those instances. As I had mentioned before, Rhode Island is an outlier in New England, and nationally we have we are tied for the lowest look-back period at 5 years currently. Examples of some of our neighbors: Connecticut has a 10-year look-back period. Massachusetts has a lifetime look-back period. New York is 15 years. Maine is 10. So basically, just looking to bring, Rhode Island closer to the national average there. And with that, if there are any questions, I'll take them. If not, I can move on to the next bill.
Thank you, Ryan. Any questions of this witness from any of the members? Representative Knight.
It's not a question. I just want to say this is a really good idea, and I thank the sponsor for bringing it. It's Rhode Island is way behind the times in this area.
Thank you, Representative.
Thank you, Representative Knight. Any other members of the committee have a comment or a question? Hearing none. Edie, sorry. Representative Agello.
A question for Ryan. Do you have data on numbers of people that would be affected by this?
Offhand, Representative, I do not, but I can find some for you. Is there anything specific you're looking for on that, or just kind of some raw numbers?
I guess I'm just interested in raw numbers. I know that that when we think of people who drive while under the influence, we also recognize that probably these people are driving under the influence when they're not caught, as well as when they're caught.
Right.
And so I guess maybe what I'd be interested in is seeing how many cases as a percentage or whatever New York and Massachusetts see with their considerably longer look-backs. I guess that's the sort of numbers that I'm looking for.
Sure, I think that's an interesting question, and I'm happy to follow up with you on that, Representative.
Thank you.
Thank you, Representative Agello. And any other questions from the members of the committee? Thank you, Ryan, for your testimony on this bill, but stay with us. So that that concludes the testimony on House Bill 5871. And now we have House Bill 5724, which was sponsored by myself. So you may proceed on that one as well.
Thank you again, Madam Chair, and thank you for introducing this bill on behalf of the AG. This bill would amend what's commonly known as the wiretap statute to make felony violations of the human trafficking statute a designated offense, which would mean our office would be authorized to petition the court for a wiretap. Now, these are instances that are very, very serious offenses if you look at the human trafficking statute. These are not aimed at prosecuting sex workers. They are not the target of this. These are really the traffickers, the folks who manipulate, who coerce, who force labor and sexual servitude on people. And we believe this would be a valuable tool in the prosecutorial toolbox, as it would help us gather evidence and infiltrate these often very, very difficult to infiltrate organizations. And as such, we believe this could help us protect a vulnerable population which is often either unwilling or intimidated or unable for some reason to come forward. Basically, this would allow us to, better gather evidence to build stronger cases to go after this very, very serious conduct. But this is, just a note for the committee's benefit. We're not creating any new penalties. We're not doing anything like that. We're just looking to better gather evidence to prosecute these cases. And with that, if there are any questions, I'm happy to take them.
Thank you, Ryan. I like this bill as well. So with that, we have...
Thank you, Chair.
Chairman Corvese has a question.
Ryan, how are you tonight?
I'm doing great, Chairman. How are you?
Good. Ryan, I like this bill also. I'm
Thank you,
surprised.
Chairman.
As a layman, I'm surprised that this is not already included, that such a heinous crime would not be included in a law that would allow for the interception of wire or oral communication. I guess I'm just a little surprised by that. And there's...
Agree, and that's why we're trying to fix it.
Okay, thank you.
Thank you.
Representative Place.
Thank you. Not necessarily a comment on the changes that are being requested. I think I'm on board with that. Just a curiosity question, and this is for the lawyers in the room, I guess, more so than anything else. On the first page on line 16, it talks about bribery, larceny involving receipt of stolen property valued more than $500. And I'm just curious if this is possibly a situation where, in conversations, we had talked about how the level had been moved from $500 to $1,500 on certain offenses.
That's a good question. Ryan, are you still there? Did you hear?
I am still here, and that is a very interesting point that you raised, Representative Clay.
Because, I mean, in my mind, it almost seems like we've lowered the bar for this. We should increase the bar a little bit higher based on the standard across the book of laws.
Sorry, go ahead, Chair.
Representative Knight wants to put in his 5 cents here.
Maybe 10.
10, 20.
A few years back, we did a Justice Reinvestment Initiative, and it changed. We adjusted, this occurred before I got here. So this was actually part of the Justice Reinvestment thing. It was rethinking crimes, and there was an across-the-board effort to change all the larceny crimes to values that kind of matched more what we would expect today. I would bet dollars to donuts that the $500 in the wiretap statute is tied to the old standard, and they just never changed it.
So again, I'm just wondering if we're in here playing with this legislation now, this is a good opportunity to maybe drop in a sub A and go ahead and bring it up to
Good
par.
point. Very good point. Ryan, did you hear what Representative Place was saying?
I did. I'm happy to take that back and look into that with the team at the office and speak with the committee again on this.
Yeah, I mean, I'd be more than willing to amend so long as the Attorney General's in favor as well, and I'm sure that they probably will. So thank you, Representative Place, sorry about that, and Representative Knight. And any other questions or comments? Seeing none, thank you, Ryan. As always, it's a pleasure.
Chair.
And that concludes the testimony on House Bill 5724. So that brings us to, are you? To this one?
Either one.
Yeah.
He's going to testify on both of those. Oh, the mayor.
The mayor's going to testify on these?
On two bills.
On the gun bills?
The bills that I just gave you, that you wrote down.
5991 and 5992. Those are Rep. Chip and Dale's.
I know, I think we've got to go to, can you hold, Jill? We were supposed to call they were supposed to call the mayor back at some point for 2 bills, but we haven't. Mayor laws, so we probably should.
Yeah, I'm going to look, I wrote it down here.
All right, we got the bill numbers. All right, call the mayor. All right, give him a call, get him on the phone, all right?
Is that one of these two? They're on the two last bill, 5991.
He's on one of the
Okay.
lists.
We're gonna.
He's on the list.
Yes, okay, we're gonna go back to House Bill 6083, which was an Attorney General bill again, sponsored by Rep. Slater, and I believe Mayor Alorza wanted to testify on that bill, and it's an act relating to Food and Drugs Uniform Controlled Substances Act. It reclassifies simple possession of 10 grams or less of a controlled substance classified in Schedules 1, 2, 3, 4, 5 of the Uniform Controlled Substance Act to a 2-year misdemeanor instead of a felony. No answer? It is getting late. Okay, so I guess we're not going back to that. Just so the Mayor Laza knows, we did try a second time. Sorry we were so late. So that concludes testimony on House Bill 6083. So now we're going back to Rep. Chippendale's bills. We're going to bring both of those into play. That's House Bill 5991 and 5992. And just so everybody knows, we're going to keep everybody to 2 minutes. We have a lot of witnesses here. And I believe we're going to start with Frank Sakosha, because there's so many. That's what Craven told, you know. That's what Craven said. We have, I think we have 80 witnesses. Good evening, Frank Sakosha, are you with us?
Yes, I am.
All right, Frank, you have the floor. We have both bills in play, House Bill 5991 and House Bill 5992, both sponsored by Rep. Chippendale.
All right. Thank you, Madam Chair, members of the committee, and everyone that's listening on this. My name is Frank Sakosha. I am the president of the Rhode Island Second Amendment Coalition. I'm also an attorney licensed in Rhode Island, Massachusetts, and the federal courts. I worked with Rep. Chippendale on this to do the research and to draft this legislation on both of these bills, House Bill 5992 and House Bill 5991. Both of these bills, what they aim to do is extend the Castle Doctrine and to make some new changes to that, to extend it, one, to carjacking, and the second one to make it applicable all across the board, almost similar to other states that have a stand your ground law. So as a brief introduction, people are unaware of, the Castle Doctrine is a doctrine in law. A lot of states have this, in which in the event that you are attacked or someone is trying to harm you, you are allowed to use the reasonable amount of force up to including deadly force without having to retreat to the farthest wall or retreat before utilizing this. Rhode Island general law under the section that we're dealing, which is 11.8-8, what it actually does is it compartmentalizes and kind of pigeonholes the Castle Doctrine, and it doesn't really come into play. It's not similar to what other states have, so we try to make it a little more even over the board. Under this particular section, the only time that the Castle Doctrine would come into play is in the event on the criminal offenses enumerated under 11.8.2 to 11.8.6, which is a breaking and entering on this in a dwelling house. That's basically the only time you'd be able to utilize this without having to retreat on this. The changes that we have here in House Bill 5991 would add in a carjacking section, so you would be able to use, it would extend the Castle Doctrine to the vehicle you're driving, so you can use a reasonable amount of force at that time to either stop the attack or, in the event that it's reasonable, to use deadly force. That the other bill, 5992, would extend the Castle Doctrine and make it more of a stand-your-ground type of legislation on that, where if an individual is lawfully where they're supposed to be in the event that they are attacked, and it would extend it not only to the crimes enumerated in 11.8.2 or 11.8.6, it would go to any violent attack against you. You'd be able to use a reasonable amount of force, and there'd be a presumption, a rebuttable presumption that that force that was utilized was reasonable. Okay? If you're looking at some of the case law, the Castle Doctrine in Rhode Island has actually been extended by the Rhode Island Supreme Court and has been expanded. Normally the legislature is the one that comes in and expands it and tries to revise the law to make sure it covers what it is supposed to be covering. One of the cases that is important on this is case state. I'm sorry.
No, Frank, go. You can proceed. You are the expert in this, so we want to give you the time to explain your position. So.
Okay, I'm sorry. Right. So one of the cases that the Supreme Court actually came in and extended this is a case called State versus Fetzik, F-E-T-Z-I-K. And in that case, in 1990, the Rhode Island Supreme Court actually extended it because under the current Castle Doctrine, you would have to, the perpetrator would actually have to be committing a breaking and entering at the time. And in that case, the individual actually came through in the department through an open door. And there was a real concern about whether the Castle Doctrine applied because it technically wasn't a breaking and entering. And in that case, the court actually did extend it to say that you are able to utilize the Castle Doctrine that in that particular situation, if somebody actually comes in to your dwelling house by any means possible, it doesn't have to be a breaking and entering if the door is open. So the court actually extended it where the legislature didn't. Another case in which the Supreme Court actually extended the Castle Doctrine was in 92, in another case called State versus Walton, in which an individual was actually invited into the house, was a guest, and then the situation in the house, because of alcohol or whatever, it fell apart, and then there was a deadly encounter at that point when the person was asked to leave and they didn't. A fight ensued. The court actually went even further to say the Castle Doctrine does actually apply in that case, where to an individual who was initially entered as a social guest but then became a trespasser when they remained on the premises after being told to leave so, and the court actually extended it to that. So the court has actually extended it further. What we're aiming to do with this legislation is actually bring it even further to say not just your house or what is considered the curtilage, which is the property outside it'll be extended to anywhere you are lawfully entitled to be. So that would cover other extended dwellings and basically anywhere out in the public. It'll be that you do not have to retreat. Now, currently, this is different, and I want to make sure that people understand this is a little bit different than the law right now concerning self-defense. Self-defense does not have that immunity from civil and criminal liability later on. The current self-defense law permits an individual, if they believe they are in imminent peril of serious bodily harm, they can use such non-deadly force as reasonably necessary just to protect themselves, a little bit different than the Castle Doctrine. And the case law is clear on this, that before you can actually resort to the use of deadly force, the person must retreat if this individual knows as aware of an open space or an avenue of escape. So this would actually kind of put it more or less, instead of having it so you would have to retreat, this would make it more of a stand your ground where if you are attacked, a violent attack against somebody, you don't have to retreat. And it gives that added protection where if you have to repel that attack on you, you now have a rebuttable presumption and you would be immune from civil and criminal liability on that. So it kind of levels the playing field a little bit, and I think it's a good next step to making sure that people that actually have to protect themselves the law actually protects them also with regard to self-defense. With that, I would take any questions from any of the members of the committee that are there.
All right, thank you, Frank, for your testimony. Are there any questions of this witness from any members of the committee? Seeing none, we'll go to the next witness, Jeremiah Yaw. You can do this if you want, you know? Is it in there? Oh, yes. Okay. Is he on? Oh. Hello, Jeremiah. Are you there?
Yes, I'm here.
All right, Jeremiah. We've got both bills in play, 5992 and 5991. So please testify as to both, and be as we're trying to keep everyone to approximately 2 minutes. So you have the floor.
My name's Jeremiah Yaw, and I live in Situate, Rhode Island, and I support the Castle Act. And that's it.
Thank you, Jeremiah, for your testimony. Are there any questions of this witness? Seeing none, we'll go. The next witness is Scott Wilbur. He's not answering. Okay, the next one is Robert Levesque, or Levesque. No answer for Robert Levesque? DeRamo's not testifying? Okay. Irving Keeley? She said he didn't answer, right? No, probably not. So there's no answer at Nicholas DeRamo and Irving Keeley. Oh, he doesn't want to testify, okay. He is in support. He is in support. So far, all the witnesses that we've stated are in support. So now we're at Richard Andrade. He's also in support. Not answering. Kenneth Castle, and he is in support. What? It is Monday. No, it's Tuesday. God, did I just say Monday? What time is it? It's 9:19. Michael Scanlon, and he is also in support. And they've signed, all of these people have signed up for both bills. Yeah, Robert Castle. No, Kenneth Castle. There's another one. Yeah, here's Robert down here. Yeah. Michael Scanlon, nothing? Okay, now we're on David Lynn. He's also in support. No answer? So, what'd you say? Oh.
I'm aware of the fact that there was an effort to get people to sign up for this. They each individually would have to sign up for the.
Right, right.
So there's no way, there's not like someone just came on and signed everybody up. Each
No,
individual
no,
had to
I'm
sign
aware
up
of that.
individually.
You're right.
So
No, they have to actually,
I think it's more the fact that it's
late.
almost 9:30 at night,
Yep.
and I don't know how many people, regardless, pick up their phones past
No.
9:30 at night.
no, I hear you. Thank you. So are we on Raymond and Tanya the third? Okay. David Line, okay. Hello, David, are you with us?
Yes.
Okay, so we put both bills in play, House Bill 5991 and 5992, so you have the floor.
Okay, so I am in favor of a Castle Doctrine for Rhode Island residents. It should be assumed that if somebody breaks into your house, they are there to do harm, and there should not be a burden on a citizen of Rhode Island. If somebody breaks into their house, it shouldn't be concern for somebody to defend themselves after somebody has broken into their house.
Well, thank you very much for your testimony. Is there any questions for this witness from the members of the committee? Seeing none, thank you, David, for your testimony. Did we contact Raymond and Tanya, the third? And Raymond is in support. No answer? And this guy. Oh, yeah. Hello, Robert, are you with us? Robert Casale? Is he on the line?
Yes, I am.
Hi, Robert. This is Vice Chair Mckenzie. You have the floor on these two bills.
Thank you. How long do I have?
2 minutes, please.
Okay, I'll try to say something
If you
worthwhile
can.
in 2 minutes.
Okay.
I'll do the best I can. Okay, I guess I'm going to sum it up. I'm a retired police officer and an instructor in both lethal and non-lethal self-defense. And I think that to allow an individual, a law-abiding citizen who has legally obtained a firearm to properly defend themselves, whether it's in their own home or any place else, they might be lawfully. I think the changes to the current bills, the amendment, the additions that are proposed between these two, speak loudly to making it clear that law-abiding citizens have the right to protect themselves and will have a presumption, that's the key word, presumption, that they acted in self-defense, which of course, however, they will have to justify that in a court of law as always. No one is suggesting that anybody be given the license to shoot somebody or use any other form of lethal force against anyone unless it's in proper defense of themselves or another loved one, as it relates to either death or serious bodily injury. I guess that's about it. That's about as much as I can say at this point. If I go on any longer, I'll be here for 3 days and you'll throw me out.
Well, thank you, Robert. Thank you for your testimony. Any questions from the members of the committee? Seeing none, that brings us to the next witness, which is Teresa Casale. Hello, Teresa, are you with us? Teresa Casale? Teresa? I guess bad connection. So we'll go on to the next witness, Eric Ekroth. Teresa was in support of this legislation, of both pieces of legislation, and Eric Ekroth is also in support. Eric Ekroth. Eric doesn't want to testify, but he is in support. Next is Greg Jackson, and Greg is also in support of both of these pieces of legislation. What'd you say? Okay, no answer. Next is Joseph Post, and he's from the Massasoit Gun Club, and he is in support. Okay, no answer for, which one are we now? Joseph Post. Next is David Eklund, and he's in support. Eklund. Hello, David. Are you with us?
Hello, this is David Eichland.
David, welcome to the House Committee on Judiciary. And we have two bills in play, House Bill 5991 and 5992. You have the floor.
Thank you. I think Frank Sakoshia pretty much summed up what I was going to say, and I'm in supporting both of those bills. So I don't really have anything else to add. I know you got a long night ahead of you, so that's all I have to say.
Well, thank you, David. Yes, Frank did a very good job of putting all the facts across to all of us. So any questions of this witness from any members of the committee? Seeing none, thank you, David. And next is Cheryl Confrida. Yeah, everything. Just these, that's the only one left. You can do that. You want to do that one? No answer. Cheryl Confrida was in support, and there is no answer. Next is Mark Mora, and he is in support. Mark Mora didn't want to testify? Oh. All right, we're on Raphael Johnson, and Raphael Johnson is in support. No answer? Okay. Next is Tim Johnson, and he is in support. And that was, what, Tim Johnson? Okay, no answer for Tim Johnson. Next is Edmund Mora, and he's in support. Okay, so Edmund Mora, no answer. Joshua Ruhi, and he's in support. There was no answer for Joshua Ruley. Now we're on Alan Ghiberti, and he's also in support. No answer? Okay, we're going to go to the next list. And there's only 3 that are different from the prior list. And that is Mark, is it Mark? Mark Mascarone? No, we already called him. And Robert Levesque, you already called him, so go to Mark Mascarone. And Mark is in support of House Bill 5991. He only signed up for one of them. Okay. Yeah, Paul Silva is next. He, as well, he only signed up for House Bill 5991, and he is also in support. No answer. Next, Alex Castoza. Alex Castoza is opposed to this legislation, and he's opposed to House Bill 5991. No answer. And the last witness is Michael Vellucci, who is in support of House Bill 5991. No answer from Michael Vellucci. So that concludes the testimony on House Bill 5991 and 5992. Thank you. Oh, excuse me. Yes. Representative Bella Wilkins.
I'd like to know if I could go on the record with testimony in support of House Bill 5991.
Oh, absolutely.
Okay.
Absolutely. Sorry about that.
Thank you very much, Madam Chairman and members of the committee. I would like to speak to you about Representative Chippendale's bill, House Bill 5991, from a very personal point of view. I was in 2 separate states when I had to rely on the Castle Act. One when I was in the state of Maryland, and the second when I was here in Rhode Island. As you know, most of you know, I was active duty in the Navy. My husband was on submarines, and so we lived separately for a while. He was a geographic bachelor, and I had our very young son with us. The first time I was pregnant, I was in Maryland, and there were a group of young men who were trying to break into the bottom apartment that I was in. I was on the first floor. And I called the police, and the police weren't coming, and so I told them in my best Brooklynese to get the F away from my door. And then I reached for my Mossberg pump-action rifle, which gives a very comforting sound when you're on my side of the door. And that's what it took to get them away from my door. The second time happened when my son was a toddler and we were living in Cranston. I was still in the Navy. At that point, my husband was in the Newport Police Department, and he was working 3rd shift. We were living in a duplex, and once again, there were a couple of men, I could see them through the window, who were trying to get into the house. And I told them, once again, to get away from the door, and I couldn't understand what they were saying. One of them sounded like he was pretty much out of it. But I grabbed my rifle, and I pumped a shell into it. And I will tell you, I don't grab a gun, and I don't pump a shell into it unless I was fully prepared to fire, which I was. My feeling was it was between protecting my son and myself. I wasn't concerned about the apartment as much as the life of my young son. And it's for these reasons that I fully support H 5991. I believe that it's important, especially for those of us who are part of the 2A community, to know full well that we have the ability to protect our property, our lives, and our loved ones. I mean, that's why most of us keep guns in our houses to begin with. So I would urge this committee to support this bill. It's an important bill, and it protects people. And it saves the lives, maybe not of the person that you're shooting, okay? But certainly the people in the household that they were meaning to do harm to. Thank you.
Thank you, Representative Vella Wilkins, for sharing that with us, because it really puts a real perspective on what we're talking about. So I certainly appreciate that. Any members of the committee have any questions for the representative? Hearing none, now that does conclude the testimony on House Bill 5991 and House Bill 5992.
And that brings us to our last bill tonight. We've already heard from the sponsor, Representative or Chairwoman Vella Wilkinson. We already know that Mayor Lawzer is not going to be testifying, which was one of the reasons why we postponed this until he was available. I'm sure he had something more important to do. But in any event, we'll start with the witnesses that have signed up to testify in this bill. Since it was like 2 or 3 hours ago, it's an act related to food and drugs, and it chooses to reclassify certain drug possession crimes as misdemeanors instead of felonies. So without further ado, the first witness is Enrique Sanchez, who's in support. Enrique.
Yes, sir.
You are on the air testifying about House Bill 5384.
Okay, great. Thank you. My name is Enrique Sanchez. I am here representing the BLM-RI PAC and Providence Democratic Socialist of America, ProvDSA. I am here in support of House Bill 5384, the Uniform Controlled Substance Act. I would like to thank the sponsors for sponsoring this very important House bill. I think we understand the implications of what the war on drugs has caused for this country, for the states, for the region, for the world. I believe that as time progresses, we need to start reevaluating how we target people who use drugs, especially black and brown people of this country, especially the working people, the poor people, the marginalized communities and urban cities and towns throughout the country. The 94 crime bill under the Clinton administration was a catastrophe. It was a bill specifically aimed at black and brown people, because black and brown people are more subject to get into these situations where we face police brutality and militarization in the country. So I do believe that if we take drastic measures to not make this drug possession policy a felony, then I think we can move towards a more diverse and more inclusive society that does not target people who have been turned down by the system for a long time. So I strongly encourage, as a brown person of this city and the state, fortunately, thankfully, I've been able to not get in trouble with the law, with the drugs, all that. Been trying my best to stay on top of things, be responsible. But the same I can't say for all my black and brown friends and family and close ones. And I will continue being a support for those people who have been turned down by this system and have been charged and have been targeted as felons for having drug possessions. But thank you again.
Thank you, Enrique. Any questions for the witness? Seeing none, Anna Jane Yolkin. Anna Jane?
And how are you?
Good, how are you? You're on the air. You can go ahead and testify.
Good. Thank you so much, Chairman and members of the committee. My name is Anna Jane Yolkin. I am a co-chair of the Substance Use Policy, Education, and Recovery PAC. I'm also a public health researcher and work for an organization that works directly with people who use drugs and people in recovery. I'm here in strong support of Bill 5384 and really appreciate your all's patience for listening to this testimony tonight. I know it's quite a long agenda. So this legislation reclassifies drug possession charges from a felony to a misdemeanor. I think you heard testimony earlier tonight that talks about the many reasons why that's so important. So right now we're at a point where we're calling substance use a health condition. We're treating it as a public health condition. We have the Governor's Overdose Task Force that recognizes this as a health condition, yet we continue to criminalize people for their substance use, for this medical condition. And that felony record really prevents people from accessing things like housing and employment, education. Those are the very things that can provide support to people to find recovery and stability and health and all the good things that we want in our society. And as Attorney General Nunn said, for most people, it's not like they go to prison, but really they're just slapped with probation and this felony record that travels with them for years, decades often. I also wanted to add that this version of the bill also fully decriminalizes buprenorphine, which is also known as Suboxone. It's a medication that's used for opioid use disorder, and it's something that can really be a tool for a harm reduction tool to help keep people alive, and so we want to increase access to this life-saving medication. It also helps connect people with assessment services so that we can really help connect people to resources so that, again, we can continue to treat this as a medical and health condition. So just to give some context about felony drug possession charges in Rhode Island, in 2018, over 1,100 people were arrested for drug possession charges, and over those, half of those were people of color. And I wanted to raise that because as we're talking about racial equity and racial justice, I really see that this is a policy that can improve that. So, for example, in California, when they implemented similar legislation, they found that racial disparities in drug arrests dramatically decreased. So I really see this as a policy that can help get us towards a more racially just criminal justice system. I should also note that several other states have taken measures to reclassify drug possession charges. They range from states in political ideologies such as California to Utah to Oklahoma, Colorado, Alaska, and Oregon has even fully decriminalized the possession of drugs. And so I think that Rhode Island really can, we've been a leader in many public health initiatives. I think we could really be a leader in this way as well. I wanted to also comment on one thing. I heard Representative Noray's concerns about fentanyl. I hear you, and I know we've had several conversations about this. And I know fentanyl is very scary. You know, it's very potent. I also want to reiterate that it's like very common in the drug supply. Almost everything is contaminated with fentanyl, and most of the fentanyl is very, very, very impure, like the street level drugs. So it's maybe 2% purity, not the 100% purity, the tiny amounts where you see, you see the little pinprick in a picture and it's like this could kill the whole town of East Greenwich. It's not like that on the street. And many of the folks that I work with in my day job use fentanyl several times a day, every single day. They've built up a tolerance to it, and it's in the whole drug supply. They don't have any choice what to say because that's what's there. And so we really want to make sure that we include that because that is what people are using. And so if we are addressing this as a health concern, we do need to address that. So I'm happy to take any questions, and thank you so much for your time.
Thank you, Anna Jane. Any questions of the witness? Thank you. Seeing none, Dr. Amy Nunn is the next witness. Dr. Nunn? Dr. Nunn, can you hear me? Dr. Amy Nunn?
This is she. Thank you.
Oh, thank you. You may proceed to testify. If you wouldn't mind, could you limit your testimony to 2 minutes?
Yes. My name is Amy Nunn. I am a professor of public health and medicine at Brown University, and I'm executive director of the Rhode Island Public Health Institute. My main point that I would like to contribute this evening is that laws like this reinforce alarming racial disparities and many kinds of big social challenges. One of them is mass incarceration. One of the most important things we can do to roll back all of those problems is to change the laws, because we disproportionately and intentionally incarcerate people of color at much higher rates, and that's bad for health, and it's also bad for our communities, because we systematically remove many men from those communities. And I believe that for that reason alone, it's important to pass this legislation. Thank you.
Thank you. Any questions for Dr. Nunn? Seeing none, the next witness is Roxanne Newman. Witness after that is Mark Terrell Gonzalez. Haley McKee, no relation. Brandon Marshall, PhD. The next witness would be Brandon Del Pozo. No answer there. Leah Schumacher. Haley?
Good evening, Chairman Graven. Hi.
How are you?
I'm well, and yourself?
I'm well. Could you give us a short version of your long story?
I can. However, I have concerns as I was skipped over on the call log and everybody else is ready and willing to testify. There must be a glitch in your system right now because I've got people who have been waiting for hours to testify on this important bill.
Okay.
And there's something up. So, and this is an important policy piece, so I really strongly encourage, I don't know what your system is, but I'm happy to testify for right now, but there are other people who want to be heard as well.
Okay. Can you proceed?
Sure. Hi, good evening, Chairman Craven. My name is Haley McKee, and good evening, honorable members of the committee. I am co-chair of the Substance Use Policy Education and Recovery PAC. This is our bill. We've been working on this for 3 years now. We've been engaging with everybody in the House of Representatives, in the Senate, and the General Assembly, and have been really motivated by everybody's stories of personal recovery, personal loss within the General Assembly, your care for your constituents. And we know that this bill matters to you, and we appreciate that. We've been working on this policy agenda for 3 years now. I have some responses. There are a couple of bills that have gone up tonight in regards to this issue, and we feel that this version is important because of the fact that we haven't redefined the dealer. So there's an alternative version at 28 grams. Our bill is at 28 grams. The EG's bill is at 10 grams. And I can speak from personal experience as a former IV drug user that when I would typically use, prior to engaging in IV drug use, that I would purchase diverted bottles of opioids, about 30 pills per bottle at 1.25 grams a pop. That would come in generally at over 30 grams. And I certainly wasn't a dealer. So us drawing a line under 28 grams is going to really ostracize people who should have an opportunity for a second chance. And that is what this bill is all about. So when we draw a line and call it 10 grams or 28 grams, it's kind of obsolete. We're not redefining a dealer or people's behaviors. We've created a system for the past few decades that has failed, and that is the war on drugs, which is largely a war on race and class. And what we're asking with this bill is to give people an opportunity who have substance use disorder, may or may not have substance use disorder, so they're not ostracized further from our communities or from our society. And our data shows that 40% of our arrests in Rhode Island come in at over 10 grams. So if we were to set a line at 10 grams, should we implement a policy piece, we'd be essentially ostracizing almost half of people based on some sort of arbitrary number that we've created and limit their opportunity. And I can speak firsthand as a person who has had opportunity to re-enter society, to be a productive member of society, to have a job that is meaningful, which is everything, an opportunity, which is everything, and a loving family, which I am grateful for. When we strip these opportunities away from people and we incarcerate them, or we give them felonious crimes, it limits their chances at survival. And substance use disorder is pure hell. For anyone who's survived it, and I don't know a single person who has substance use disorder that didn't have some sort of loss or trauma or some sort of condition that really kind of exacerbated, like, feeling like they had to self-medicate. So we applaud people for recovering from this condition, but we're criminalizing them in the meantime. And I want to push back a little bit on Rep. Noré, and I understand from your law enforcement perspective, like, where you're coming from. Law enforcement perspective sees people in their worst moment, and oftentimes it causes their worst moment. I work with people living with substance use disorder every single day, and I counsel them, and I see these people in their best moments, where they shine. And I can say that the war on drugs does not work. It's racist, it's a class war, and it needs to stop. So, I welcome any questions, and I strongly encourage, because I know Brenda Del Pozo is waiting to testify. All of these people who you called prior to my name, and fortunately, I was linked up with the bill sponsor, everybody is waiting to testify on this bill. We've been working on this for 3 years. It's over 1,100 people in Rhode Island that incur a felonious charge for a symptom of a medical condition every single year, and every single one of these voices need to be heard tonight. And I know it's late, and I appreciate your patience, and I thank you for your time, committee members.
Haley, could you give me the names of the people that you know that we've called, or we've said we called and said they didn't receive a call?
Sure. So if you haven't heard from Mckenzie.
Well, let me
Dr.
give you,
Liz
hang on,
Samuels.
Haley. Let me give you the names of the people we've called. Is it Roxanne Newman?
She's waiting.
She's waiting.
Yes.
Mark Terrell Gonzalez?
Also waiting. I just spoke with him.
Brandon Marshall, PhD?
Dr. Marshall is also waiting.
Brandon Del Pozo?
Yes. He had a strong response. He's also waiting.
And Leah Schumacher.
I'm not sure who she is, but I'm sure she has important input. And there's a lot of people who additionally are prepared to testify on this bill.
Okay, we'll try to call those 4 people back. Thank you for your testimony. And
Rep. Craven,
yes.
may I ask, do you have additional people on your roster for this evening to testify? Because there are other people who are looking to do so.
There are 4, 8, 12 more people, 13 more people to testify.
Beautiful. Thank you. Thank you for your support. And thank you for your messaging. Everybody over in the General Assembly, we miss your faces. Thank you so much.
Thank you, Haley.
Bye now.
Felicia Delgado is the next witness. Felicia, you're on the air.
Yes, hello.
Hi, how are you? Could you limit your testimony to a couple of minutes, please?
I sure can, as long as you listen and get my point across.
Absolutely.
Okay, I know that everyone's tired and it's a long day, but I'm calling on, I'm testifying on the behalf of decriminalizing when people get pulled over for having OxyContin and they're trying to get off of medication. Everybody has an opinion today. Everybody has an opinion, but we tend to not look at the other side. I'm trying to rush my comments. Last year, there were 88% of the arrests were black individuals in Providence that got arrested for this. Okay, people are trying to survive today, and they're trying to, the opioid, OxyContin is an opioid that they're trying to get off other medication, and they're trying to focus. But now we found a new way to support the criminal system, either by incarcerating somebody so we can keep the grant up, so we can keep the federal dollars coming into the state of Rhode Island because our prisons are full. Okay, I know you want it to be short, but it just doesn't make sense. It's like, let us thrive in what they so-call the hood. Because as long as these individuals, it doesn't matter, black, white, Asian, these people of poverty stay in these crippling life situations where they try and survive by doing whatever, you know, and then they get caught up into a drug life, and then they try and get out of it, they get arrested. We're having opioids that are trying to help them get out of it. Whether you agree with me or just like we've had it up to here, the realization is that you are incarcerating people that are trying to get their lives together. And what did they just have, some type of raid, was it last year? And like all you got was you spent thousands of dollars and you only got like 4 pills? Because you are more concerned about people that are white collar getting their jobs filled. As long as there's people in jail, you're paying for the judge, you're paying for the officer, you're paying for they all have jobs, the correctional office. As long as we keep people in jail, everybody else around us gets to keep their jobs. Because, hey, we got to have the police, we got to have probation officers, while people are just trying to, especially in today's society. Especially in today's society. If you look at the numbers, if you look at the numbers and what's going on.
Do one at a time.
Huh? Excuse me?
You got 30 seconds, please. Thanks.
I guess I was really listened to, huh?
Yes, you were.
I'm sure. All right, thank you.
Thank you.
Oh, they're so full of it.
Melissa Mckenzie is the next witness. Michelle Mckenzie?
Yes.
Michelle, you're on the air. Please go ahead.
Okay. Thank you, Chairman Craven and members of the committee. Thank you for allowing me to testify tonight, and I am testifying in support of House Bill 5384, which reclassifies simple drug possession from a felony to a misdemeanor. I'm a public health researcher who has dedicated my efforts toward overdose prevention and reducing fatal overdose for the past 15 years. I direct Preventing Overdose and Naloxone Intervention, which is PONY. It's a program in which we train folks on how to prevent overdose and how to respond in case of an overdose. And I'm also a person in long-term recovery. In my work, both through doing research and in training folks and distributing naloxone, I have the opportunity to regularly speak with people who have saved a life, sometimes many lives with naloxone, and talk to folks. The people that I'm speaking with are people themselves who use opioids and have a history of criminal justice involvement based on their substance use. And so I not only get to hear about them saving lives, but what happens in response in the things that are going on around them whenever they want to save a life. And I have to tell you that a common theme in these conversations is fear of law enforcement. And this fear does not keep people from using drugs, and it couldn't, because that's just not how addiction works. But it does keep people from accessing resources. For instance, I've talked to a number of people about one strategy to reduce overdose deaths, which is an opioid prevention center. And while consistently people think that that's a great idea, particularly people who are marginalized and end up using in public places, in parks, and who would really like a safe place to use and to have access to resources, they speak of fear of law enforcement and absolutely having difficulty to believe that they wouldn't be targeted by law enforcement if they were to utilize such a resource, if it existed, of course, here in Rhode Island. Additionally, when people talk about responding to an opioid overdose, they talk about the fear of calling 911, and if they do call 911, leaving the scene when police arrive because of fear of what will happen. And we know that even though we have the Good Samaritan Law, which is very important, but arrests continue to occur at the scene of an overdose in Rhode Island. So why is this important? I mean, obviously there's many reasons that we don't want people afraid to access resources and to help people. But a reason it's particularly important now is that in 2020, more than 400 Rhode Islanders lost their lives to overdose. We more than ever need to use all the tools in our toolbox to save lives. And for several years now, we've heard the refrain, well, we're not going to be able to arrest our way out of this problem. But unfortunately, we haven't really made the major shift that needs to happen to make that a reality. And we're here today to ask you to change the law so that we can make it more of a reality. And just a couple of things. I want to reiterate one of the things that Anna Jane Yolkin said earlier about fentanyl being a major part of the drug supply. People who use opioids, there is no heroin. There isn't heroin in Rhode Island anymore. It is fentanyl. I mean, so it is a regular part of the drug supply. And as other people have said, it is it contaminated a lot in a lot of different drugs, not just opioids. And so the idea of somehow separating fentanyl out is not recognizing the reality of the drug supply now. And their fentanyl represents typically 2%, 2 to 3% of a baggie, or it's a tiny fraction of the amount of the drug that somebody takes. And I think Anna Jane also mentioned that her clients who are using fentanyl multiple times a day, because fentanyl is very fast acting in the body, faster acting than heroin is, that means that people are going to have more of this substance on them for their own personal use. So I think that the fact that this is a 28 gram as opposed to the 10 gram that the Attorney General's bill is really, really important in making a difference to really chip away at this idea that we can move, that this is a criminal justice problem and that we're moving more into the realm of public health. So thank you so much for staying late and listening to my testimony. Thank you.
Thank you very much for your testimony. Are there any questions of Michelle? Seeing none, Sarah Edwards is the next witness. Mark Terrell, okay. Mark Terrell Gonzalez.
Yes.
You're on the air.
How are you?
Good, how are you?
I'm okay. So what do I just start?
Yes.
Speaking on the bill?
Yes.
Okay. Well, the bill, in my case, for one example, I was picked up and I was searched and arrested because I had one of my own medications on me without the bottle. And because of this, they were going to violate my probation. My doctor was on the phone. When they said they were charging me, the captain from the police department didn't want to accept the fact that my doctor was telling him he can send him any necessary documents. Felony drug possession at a young age for a simple charge, especially like back in the day when they used to charge for weed, marijuana, cannabis, it can ruin someone's life for something so small. Someone's experiment in college, which we all have relatives, family, sons, daughters, cousins, nephews, best friends, kids that went to college or something and experimented, and why ruin someone's life, because someone experimented, based on, what the police can prove on the charges, I could see, but, in most cases, there's a large percent of arrests, especially in lower income communities that are mostly drug possessions. Like I said, they charged me with my own medication. I had to go to court like 5 times because the prosecutor, when I got arrested, I went to the hospital and because I take meds, and I asked them for a copy of my med list. It showed my medication on there, and they were trying, and this is after 4 years of being clean, after, serving my time for other charges and, being released and being home and working hard, going to college, working at a drug program that I once had to reside in. when they searched me, I had my computer, my school books, you know, and it was really traumatizing thinking that for one of my own medications, they were trying to charge me with a felony possession. You know,
Mark, you've got 30 seconds to finish your testimony, please.
Okay, and you know, I just think things need to be considered a little more before charges like that are being filed against people. And I mean, it really can ruin someone's life, and especially when they're young and it's their first charges, or after they've turned their life around, and you know, the charges aren't really. The charges are more based because they have a history of arrests instead of actual what the charge should be.
Thank you, Mark, for your testimony. Are there any questions of Mark Gonzalez?
No, thank you.
All right, thank you very much. Next witness is Brandon Del Poza. Brandon?
Yes.
You're on the air. You can begin to testify now. You've got 2 minutes.
Thank you very much, Chairman Craven and members of the committee for circling back and taking my call.
My pleasure.
I'm Brandon Del Pozo. Yeah, thank you. I'm a PhD postdoctoral researcher at the Miriam Hospital and the Warren Albert Medical School at Brown. I'm a colleague of Dr. Jody Rich, and I come to Rhode Island by way of 19 years in the New York City Police Department and 4 years as the Chief of Police of Burlington, Vermont. In addition to being a chief of police in New York City, I commanded 2 police precincts and worked in the chief of department and commissioner's office. The reason why I came to Rhode Island is because in learning about the opioid epidemic in Vermont, we saw Rhode Island as one of the national leaders in its response to the overdose crisis, especially in the way it afforded medication-assisted treatment to everybody in jail and prison. And we set about copying Rhode Island in its methods in Burlington, where I was the chief. I led the public health response in our response to the overdose crisis. So I'm calling tonight to see if, even though, you know, Vermont is geographically close to Rhode Island, but in many ways spiritually pretty far, but maybe this is one area where we can have common ground. As a chief of police, I was the first public official to de facto decriminalize the unprescribed possession of buprenorphine. I did it as a response to the overdose crisis, and that and a bunch of other interventions coincided with a 50% reduction, statistically significant 50% reduction in overdose deaths in Burlington. So I know that it's a long night. I just wanted to highlight a few pieces of evidence. I'm speaking tonight narrowly about buprenorphine decriminalization because I can speak to that from experience. I can't speak to the other, things on the bill from experience. But I'll say that there was a study that was just completed in Rhode Island by Dr. Rachel Whiteman at Miriam and Rhode Island Hospital. She's a researcher under Jody Rich, a colleague. She analyzed over 550 overdose deaths over 2 years in Rhode Island and found that only 4% of them had anything at all to do with buprenorphine. And in every case, those overdose deaths were also accompanied by a much more potent substance that was already in the person's bloodstream. As a researcher, I recently completed an analysis of 1,750 opioid overdose deaths in Marion County, Indiana, using toxicology reports. Only 2.8% of those, about 49, had anything to do with buprenorphine. And in 48 of those cases, the other drugs in there, fentanyl, methamphetamines, heroin, carfentanil, fentanyl analogs, were all sufficient to cause the death on their own. So I'd offer you that buprenorphine has little to no effect on overdoses in people's bloodstream, but it is an extremely important life-saving medication. So my experience as a chief of police, and I'll just wrap up by saying this in about a minute, is that people were using buprenorphine to self-medicate. They were using buprenorphine to get over the danger of heroin and fentanyl being out there. And even if they weren't ready to accept treatment, we found that just taking fentanyl for the day that they took it reduced their overdose risk for that day. So I'm not proposing that this legislation be a long-term decriminalization of buprenorphine, although many people would like that. At least in the short term, with the overdose crisis being as bad as it's ever been, this is a way to effectively save lives in Rhode Island by giving people the safest possible alternative to the drugs that they are struggling for addiction with, and doing so in a way that they won't be afraid if they have it in their pocket, it'll land them in jail. So, my experience with response to the opioid crisis came from following Rhode Island by way of Vermont, and now I'm honored to be in Rhode Island trying to bring some of that experience to the fore. And I think that this part of the bill is a very important one, and I urge you to take it seriously. I don't think there's any downside to it.
Brandon, thank you very much. We're glad to have you here in Rhode Island. It's an honor.
Yeah, thank you very much. Thank you.
Any questions of the chief? Okay.
Former.
No, you're always a chief. Thank you. The next witness is Leah Schumacher. Leah,
Yes, this is she.
you're on the air. You can begin your testimony.
Yeah, hi. Thank you for hearing me tonight. My name
Leah,
is
you
Leah
got
Schumacher.
about 2 minutes, if you wouldn't mind.
Absolutely. I'll keep it brief. My name is Leah Schumacher. I'm a resident of Providence. I'm a psychologist and a researcher, and I'm calling in support of Bill 5384. In my mid-20s, I worked at a residential drug and alcohol treatment center in a different state. It was a really unique facility. Women who were trying to recover could live there with their children. It was really a privilege to see these women making so many changes in their lives, working so hard. Unfortunately, however, I also saw many opportunities where having felony charges were huge, huge barriers to getting employment, getting independent housing. And so I support this bill and reclassifying possession charges, because I don't think people who are working to make changes when it's already so difficult need any more barriers to building better lives. So thank you for hearing me.
Thank you very much. Any questions of the witness? Thank you. The next witness is Sarah Edwards. Sarah?
I am here.
Sarah, you've got 2 minutes to testify, and you're on the air, and you can proceed now.
All right, thank you. I will be quick. Hello, Chairman Craven and members of the committee. I am testifying in support of Bill H5384. Thank you, Rep. Bella Wilkinson, for sponsoring this bill. And thank you so much to everyone for taking the time to listen to my testimony. I know it's been a long night. My name is Sarah Edwards. I'm an outreach worker that specializes in harm reduction and recovery efforts. I am also a person in long-term recovery from substance use. So we encourage those who seek out recovery to move forward and increase the quality of their life. But how is this done when a felony looms over an individual's future, affecting their opportunity for employment, education, stable housing, and so forth? How is someone to rebuild their life when they're met with obstacles everywhere they turn? To put it simply, criminalization of personal possession is a setup for failure. Prison is not a rehabilitating environment, and substance use needs to be treated as the health and civic issue it is, not criminal. I think it's also important to acknowledge the discriminatory enforcement of drug possession laws and how it disproportionately affects people of color. This ongoing war on drugs is built on racist and classist policies and has no productive outcomes. I think it's a contradiction to preach the words of support for people who use drugs or people who have substance use disorder and then turn around and criminalize their disorder. I would also like to note the importance of increasing the weight threshold, specifically with this bill. As a person in recovery from polysubstance use, I could tell you that on any given day that I had the funds to do so, I would have multiple substances on my person, including pills, which obviously weigh more than a powdered substance, which cumulatively would most likely weigh over 10 grams. And I had zero intent to distribute. This was for my personal use. I also want to say in conjunction to that, in regards to buprenorphine, I did not have any access to Suboxone where I was living. I lived in a very rural area, so getting connected to a Suboxone clinic was really just not within my realm. So I bought Suboxone off the streets when I was trying to stop using substances because that was my only option. So I just wanted to add in that personal anecdote. I can go on and on about the negative impacts that criminalization of substance use imposes, but for the sake of time, I'll keep it short. In conclusion, if the state is serious about saving lives and supporting people who have substance use disorder or are seeking recovery, then we must consider this bill very seriously. So thank you for taking action on this important public health issue, and thank you so much for your time.
Thank you very much. Thank you for your testimony. The next witness is one name, Diego.
I just wanted to add that personal anecdote. I can go on and on about the negative impacts that criminalization of substance use disorders of the state. In conclusion,
Witness is one name. Bill?
Mckenzie, are you on the air?
Yes, I am, Chairman.
Please turn down the volume on your computer.
How's that?
I hope so, it's good. You can begin to testify, you've got 2 minutes.
Okay, thank you, Mr. Chairman and committee members. My name is Mckenzie Rankin, and I'm a former correctional officer with the Rhode Island Department of Corrections, where I served for 13 years. I currently serve as an advocacy chairman and community engagement coordinator for a nonprofit that works with people who are struggling with substance use disorder. I'm calling tonight in support of Bill 5384, and I would just like to start off by saying I heard a lot of language tonight about substance use disorder being a public health issue, and based on the 1962 Supreme Court decision of Robinson versus California, the Supreme Court had already decided that the Eighth Amendment clause of cruel and unusual punishment, it was against that to punish a person for their illness, which in this case would be their addiction or their substance use disorder. So the criminalization of this has been far too long going on, and as everyone knows, it has disproportionately impacted minority communities. We understand that addiction is not an issue of moral failing, because as we see rural communities where salt-of-the-earth individuals who do not look like me, I'm an African American, are now suffering and struggling with the scourge of opioid addiction, we find that it's poverty that's at the root of this. And as a former law enforcement officer, I understand that law enforcement officers might feel a little bit threatened by a disruption in the law enforcement complex, where this pyramid scheme of police officers are on the street arresting people for these crimes, and then they get put into the court system where you need to have more judges and more sheriffs, and then you need to send them off to the prison where you need to fill up the cells and have more correctional officers. Our state and our nation has spent a very long time touching a hot stove and expecting to not get burned. We know that this carceral system does not work. We know that we are not helping anyone. And based on a letter that I saw earlier produced by the Police Chiefs Association, the concern is that there's infrastructure for treatment. So maybe if we started to reallocate funds away from the military materials such as armored personnel carriers and sniper rifles and all these other materials that are needed for quote-unquote crowd control or urban pacification, if we started directing that money towards actual treatment and recovery, what we know works, then maybe we'd be in a better place. So with that, I'll say thank you for your time, and I hope everyone has a good evening. I appreciate your time.
Thank you very much for your testimony. The next witness is it Hannah? Hannah Stern? Hannah.
Hello.
You're back again. Make sure he pays you overtime.
Back again. I will. I'll put in a request.
Okay, you're on the air. Go ahead.
We go? Perfect, thanks. Thank you again, Chairman and members of the committee, for your time this evening. I know it's been a very long night. My name is Hannah Stern. I'm testifying on behalf of the ACLU of Rhode Island in strong support of this legislation. And we'd also just like to thank Representative Bella Wilkinson and the sponsors for introducing this bill. The many advocates on this legislation have done a great job describing the merits of this bill, so I'll be very brief. As has been noted, not only is this a critical piece of racial justice and criminal justice policy, but what this legislation does is ensure that our public policy and our public health initiatives relating to substance abuse are harmonious. So Felony convictions can impact treatment. They can affect the supports that individuals need for substance abuse treatment, and they can make it much more difficult for justice-involved individuals to access healthy housing and stable employment. So the reclassification that this bill proposes really ensure that Rhode Island's approach to reducing substance use is non-punitive, appropriate to what individuals actually need, and centers important tenets of criminal and racial justice. We hope this bill sees passage. Thank you very much for your time, and I'd be happy to take any questions.
Any questions for Hannah? Thank you very much. Go to sleep.
Have a good night.
Take care. Gray Gardner is the next one. Gray?
Yes.
You have to turn down the volume on your computer.
Yes, it's down. Thank you.
And you have 2 minutes, so proceed.
Thank you. Chair Craven, members of the committee, thank you so much for the opportunity to testify today in support of House Bill 5384. We also want to thank Representative Bella Wilkinson for introducing the bill. My name is Gray Gardner. I'm a senior staff attorney for the Drug Policy Alliance, which for over 30 years has been the nation's leading organization working to advance drug policy centered around health and harm reduction rather than criminalization. Prior to joining DPA, I worked for more than a decade as a public defender representing individuals charged with criminal offenses in the District of Columbia and New York. And part of that work included helping clients who were struggling to expunge or seal criminal records that were creating ongoing barriers in their lives long after their sentences expired. As several of the speakers have already pointed out today, felony drug convictions make individuals less employable. They limit opportunities for education, occupational licensing, housing, parental rights, business loans, immigration status, and voting. And by limiting opportunities for people with those convictions, these convictions exacerbate pre-existing trauma and addiction and instability. The evidence just does not show that incarceration or labeling individuals as felons is in any way successful in reducing drug use, addiction, or drug supplies. 18 states now treat drug possession as a misdemeanor, including Pennsylvania, Delaware, Massachusetts. And since just 2014, 6 states have lowered their penalties. California and Oklahoma, as AJ mentioned earlier, did so by ballot initiative, and legislatures in Utah, and Connecticut, Alaska, and Colorado have passed reforms with strong majorities. Oklahoma voters, by the way, passed these reforms with nearly 60% of the voters in support. So we urge you to, with this bill, move in a similar direction to reduce punitive sentences without any carve-outs for fentanyl or setting unreasonably low thresholds. This bill would be a step in the right direction toward treating drug use and possession, as many others have mentioned, as a public health issue rather than a criminal justice issue. And we'd be happy to work with you on these reforms moving forward toward additional improvements as well on harm reduction services and redirecting funds, resources from criminal justice enforcement to voluntary treatment. Thank you again for your time, and I'm happy to address any questions.
Great, thank you for your testimony. Are there any questions of Mr. Gardner? Thanks for your time.
Thank you.
Dr. Jody Rich.
Criminal justice.
Dr. Rich,
Hello, Chairman Craven.
how are you?
Good.
Could you make sure you have your volume down?
It should be off now.
Okay, great. Proceed. Go ahead.
Well, thank you, Chairman Craven, and honorable members of the committee, and everyone else this late hour. So my perspective is one of a clinician, of a physician, and a researcher who's focused a lot on this overdose issue for several decades. And I've worked in the hospitals and outpatient clinics, taking care of people with diseases related to addiction and addiction itself. And I've had a clinic at the Department of Corrections every week for over 25 years. And I've seen thousands and thousands of people just devastated by this disease, and then doubly devastated by their criminal justice involvement. And I can tell you, there are a few people that really the best option is to have them incarcerated for their own safety and for the safety of others. But the vast majority of them, we're not doing them any favors by locking them up and keeping them locked up for long periods of time and giving them felony charges and making the rest of their life just difficult. We're not helping it. And the bottom line is that what's worse about this disease as opposed to other diseases is the stigma. We stigmatize this disease, and we just simply can't have it both ways. We can't say this is a disease in need of treatment, and at the same time say, oh, but by the way, we're going to arrest you if we catch you with this substance, and you're going to get a felony offense, and you're going to get into trouble. So, I mean, we've heard a lot of testimony. It's been a long evening. I think some of the key issues is the Attorney General saying this is a public health issue, not a criminal issue. And when you talk about decriminalizing, it's removing the criminal penalties, but it's not removing all penalties. It's not a message to say, oh, well, everybody should go use drugs. I mean, I am strongly in favor of 5384, but I'm not in favor of drugs. I've lost so many people from drug use, so many of my patients and even family members. This is a terrible thing, but we're not going to get where we need to get to with keeping it criminalized. Just over a year ago, we had the drug czar from Portugal, Dr. João Goulão, come to spend a week in Rhode Island, and I had him meet as many people as he possibly could, and tell the story of what's been going on in Portugal, where they took the drug problem out from under the Ministry of Justice and put it under the Ministry of Health. They treated it like a health problem. And 20 years later, their overdose rate is less than 10% of ours. Their culture is not something that people are ashamed of. Their kid has an addiction problem. They tell their neighbor, and their neighbor says, well, are they getting the help they need? Are they getting the support? Are they getting treatment? And that's how you address this public health problem. An example that many people can relate to is seatbelts. It's illegal to drive your car without a seatbelt, but it's not a crime. It's not a criminal problem. And yeah, we have ways to coerce people, to encourage people, to educate people about the importance of seatbelts, and pretty much just about everybody wears their seatbelts. That's what we need in this. We need to get rid of the stigma, and this ongoing felony arrest and charge and threat of that is, I mean, we heard it already tonight. People are scared of going into treatment because they think they're going to get arrested. And I would also point out the difference between 10 grams and 28 grams, that 18 grams, I would say absolutely that's personal use. And if somebody has 27 grams on them, if they're a dealer, they're not a very good dealer. They're not a big fish. They're not, putting them, spending money and resources of the state to catch that person and get them jammed up in the criminal justice system serves nobody, serves no good purpose, and is really a waste of everyone's time. And then finally, getting to this issue of buprenorphine, Suboxone, we have not enough buprenorphine in this state. And if somebody has opioid use disorder and they want to get high or use some drugs, they go after heroin. Of course, you can't get heroin now, so they get fentanyl, or they go after pills. They don't go after buprenorphine. That's the last thing they would use. Even though it is an opiate, it is not a full agonist opiate. It's not as powerful. In fact, it is the safest of all the opiates to use, and that's why people use it for treatment. And that's what Chief Del Pozo correctly surmised in Burlington that this is not a drug of abuse. This is treatment. So for all those reasons, I strongly support 5384 and urge you to support it as well. Thank you.
Thank you, Dr. Rich. Any questions of the doctor? Seeing none, the next witness is Dr. Jennifer Carroll. And we have one more left, if that helps anybody with their anticipation. Dr. Carroll, you're on the air.
Good evening. Thank you so much for allowing me the time to testify. I know that it's late, and I will do my best to be respectful of everyone's time. So I am a medical anthropologist. I am on faculty in the Department of Sociology and Anthropology at Elon University and in the Department of Medicine at Brown University. I have expertise in substance use disorder, the risks of overdose prevention. I have worked with the Atlantic Carolinas high-intensity drug trafficking area for many years on the law enforcement side, and I'm also the lead author of the CDC's recommended best practices for overdose prevention at the community level. And so I am coming to you tonight to share not just my endorsement, but my deep excitement about this bill. I want to emphasize that the other people that you've heard from tonight are incredible. Whether it's Michelle Mckenzie, Amy Nunn, Brandon Del Pozo, Jody Rich, Greg Gardner, when the CDC has questions, these are the people who they call. When ONDCP has questions, these are the people who they call. I know that there's more than one bill that is suggesting or proposing certain degrees of decriminalization on your agenda tonight, and I really want to emphasize how important it is that these individuals are endorsing this particular bill as opposed to the other one. The reason why I'm excited about this bill is not only the aggressiveness which with it is pursuing decriminalization, which is terribly important for all the reasons you've been hearing, but I also want to underscore how terribly important it is to move forward with decriminalization of non-prescribed buprenorphine. I've also done a lot of work in Rhode Island. The study that Brandon Del Pozo mentioned by Rachel Whiteman is a very, very important one. I also did a lot of work with the Rhode Island governor's task force in 2016, 17, and 18 with people who are regular consumers of illicit and diverted opioids in Rhode Island. One of the things that we found is since long before fentanyl even came into the local drug supply, all the way back to 2009, the percent of people who are daily consumers of opioids who also engage in buprenorphine use without a prescription has not changed in a decade. So we know that this is not driving the opioid epidemic. What we do know, based on, and this is from numbers in Rhode Island, this was published in the Journal of Addiction Medicine in 2018, we know that people in Rhode Island who are using diverted buprenorphine have 5 times the odds of having sought treatment in the last year. Right? And so they are coming into contact with buprenorphine because they are trying to self-treat, because they have tried to access treatment, and because they cannot access treatment, and because they are working through a really, really complicated medical system that they have learned to not trust over time. So this is not just about taking people out of the criminal justice system. It is also about not derailing people who are trying to start themselves on the path to recovery, even if it's not the path that we might choose for them. Even if we would say it's better for you to go to a doctor, that'd be great. I would love for us to have a treatment system where everyone can walk in, feel safe, feel cared for, feel respected, and get service the same day. That's not the world in which we live. While we build that healthcare system, we have got to stop derailing people who are doing their very, very best to get back on their feet. That's why the buprenorphine decriminalization element of this bill is so, so important. So I will stop there. I'm happy to answer any further questions, but thank you for your time, and I strongly encourage you to support this bill.
Thank you very much, Doctor. Are there any questions for Dr. Carroll? Seeing none, the last witness tonight is, she's not available? Okay. Well, then that would conclude testimony on Chairman Vela Wilkinson's Bill 5384. And do I hear a motion to adjourn?
Motion to adjourn.
All those in favor signify by saying aye. Thank you very much for your attendance and the staff's help. Thank you.